Right, settle down, everyone. Welcome, KSLU law students, to this absolutely vital explainer. I am your senior law professor today, and I expect your complete undivided attention. We are tackling a definitive, high-weightage topic straight from your Contract Law 2 syllabus. When question 11 appears on your exam, asking you to explain the extent of an agent's authority and when that agent becomes personally liable, you've got to attack it with absolute precision. No vague stories, no beating around the bush. We rely strictly on the bare act and the exact letter of the law. As we run through the agenda in a moment, know that this is your exact synopsis blueprint. You must draft this at the very top of your answer script, okay? Let's dive in and make sure you secure those maximum marks from the evaluator. Here is your synopsis blueprint. 1. Agent authority and meaning. 2. Types of agent authority. 3. Exceeding the authorized limits. 4. General rule for liability. 5. Exceptions causing personal liability. And 6. Conclusion and exam strategy. Starting with heading number 1, agent's authority and meaning. Authority, the power of an agent to act on behalf of the principal and create legal relations with third parties. Now underline this heading boldly in your answer script, memorize this definition word for word. To write the perfect introduction, you must state that under the Indian Contract Act 1872, an agent acts as a vital bridge. The extent of this authority determines exactly how far the agent can bind the principal. You must explicitly use the phrase create legal relations. The examiner is specifically looking for this exact legal terminology to award you full marks right out of the gate. Moving on to heading number 2, types of agent authority. Express authority, Section 186, given by words, oral or written, clearly defines scope. Implied authority, Section 187, inferred from conduct or circumstances, includes usual and incidental authority. Now I must remind you, clearly separate these subpoints on your exam paper. Don't merge them into a single messy paragraph. Structure is everything. The distinct contrast between Section 186 and 187 is absolutely vital. You are commanded to explicitly write down these bare act section numbers in the margins of your paper. Express authority is direct. The principal told the agent exactly what to do. Implied authority, on the other hand, requires the evaluator to see that you understand it's circumstantial. It's the authority naturally necessary to carry out the express orders. Apparent or ostensible authority. Third parties believe agent has it based on principal's conduct. Authority and emergency, Section 189. Agent does all acts necessary to protect principal's interests. Let me thoroughly explain this. Apparent authority is when the principal, through their very own actions, makes the outside world believe a person is their agent, even if they actually aren't. Furthermore, for Section 189 emergency powers, the conditions are incredibly strict. The agent must act exactly as a person of ordinary prudence would act in their own case, purely to save the principal from loss. State that clearly in your answer. Case law, Freeman and Lockyer v. Buckhurst Park Properties. Recognized apparent authority, binding the principal even without actual authority. Stop your pens, look at me, listen carefully. We are doing a mandatory deep dive right here. The facts of the case are these. The directors of a company permitted one specific director to act as the managing director, even though he was never formally appointed to that role. This unappointed director went ahead and hired architects, the plaintiffs, on behalf of the company. When the architects asked for their fees, the company blatantly refused to pay, claiming he had no actual authority. Now, the ratio decidendi, the final verdict of the court, was that the company was indeed bound by the contracts made by this director. Why? Because the company, by its own conduct of allowing him to act like a managing director, created apparent authority. The absolute relevance of this case is how brilliantly it illustrates ostensible authority. The principal gets trapped by their own representations to the third party. Exam tip: draw a prominent box around Freeman and Lockyer v. Buckhurst Park Properties to immediately grab the evaluator's attention.
Heading number 3, exceeding the authorized limits.
Separable Acts, Section 227, principal bound only for authorized part. Inseparable Acts, Section 228, principal not bound at all. So what are the strict legal consequences when an agent blatantly crosses the boundaries of their granted power? Let's examine the bare act. The crucial point here is the concept of severability. Imagine an agent is told to buy an estate for 10 lakhs, but they go ahead and buy the estate and a car for 12 lakhs. Can you separate the two? If yes, under Section 227, the principal pays for the estate and totally rejects the car. But if the unauthorized act is fundamentally tangled up with the authorized act, Section 228 triggers, and the principal washes their hands of the entire transaction. The evaluator actively wants to see this stark, analytical contrast in your answer script.
Heading number 4. General Rule for Liability.
General Rules Section 230. Agent is not personally liable. Acts on behalf of principal. We are now shifting from the principal's burden to the personal liability of the agent themselves. This right here is the grand shield of immunity in the Indian Contract Act. In a standard healthy agency relationship, the agent is merely a conduit, like a connecting pipe between the principal and the third party. If a breach of contract occurs, the third party sues the principal, never the agent. You absolutely must establish this baseline before you discuss any liabilities.
Heading number 5. Exceptions causing personal liability. Pay close attention.
Contract expressly provides, agent agrees to be personally liable. 2. Principal is undisclosed. Third party may sue agent or principal. 3. Principal cannot be sued. Example, foreign principal, minor. 4. Agent exceeds authority, liable for unauthorized acts. This is where the actual examination battle is fought. This is exactly where the agent's general shield of immunity is ruthlessly stripped away by the law. You must format these exceptions as a crisp, numbered list on your exam sheet. If the principal is a minor, well, they lack the capacity to contract, so the law forces the agent to take the fall. If the principal is in a foreign country, making suing them practically impossible, the agent bears the burden. Write these down exactly as I've laid them out. 5. Pretended agent, Section 235. False representation of authority, liable for damages. Skipping to 7. Trade custom or usage. Certain trades impose personal liability. 8. When agent acts for himself, in own name without disclosure. Let me give you a deliberate classroom explanation of Section 235. A pretended agent is someone who outright lies, claiming to represent a principal when they have absolutely zero authority. If the third party suffers a loss because they believe this lie, the pretended agent must personally compensate them for the damages. It's a very strict penalty for fraud.
Exception 6 and Case Law, Collin v. Wright. Held that an agent is liable for breach of warranty of authority if he acts without authority. Halt the lecture entirely right here. Pens down. This requires a mandatory, deep breakdown. The facts of Collin v. Wright. A land agent named Wright agreed to lease a farm to Collin, explicitly claiming he was fully authorized by the farm's owner. He was not. The true owner naturally refused to execute the lease. Wright unfortunately died, so Collin sued Wright's executors for the massive financial losses he incurred. The ratio decidendia. The court established that any person who professes to act as an agent impliedly warrants or guarantees that they actually possess that authority. Because Wright breached this implied warranty, he and thereby his estate was held personally liable for the damages to the third party. Now, the absolute relevance of this case is that it forms the bedrock foundation of the breach of warranty of authority exception under common law, which directly heavily influences our Indian Contract Act. My firm exam tip to you: heavily underline this specific breach of warranty case, Collin v. Wright, to guarantee maximum marks for a 16-mark answer.
Finally, heading at number 6, conclusion and exam strategy.
Conclusion. Extent of authority determines binding effect. General rule protects agent. Exceptions ensure accountability where authority is misused or misrepresented. How do you properly close a heavy 16-mark KSLU answer? You don't just stop writing, you summarize the legal essence. This right here is your perfect closing paragraph. It ties the entire syllabus concept together in 2 crisp sentences. It shows the evaluator that you firmly grasp both the protective shield of agency and the sword of accountability. I'll leave you with a final, provocative thought to ponder as you prepare for your exams. If the protective shield of Section 230 is so easily shattered by these strict exceptions, just how immense is the legal peril for an agent who dares to take even one step beyond their defined boundaries? Master the bare act, cite your case laws boldly, and you will dominate this exam. Keep studying.